All right, welcome everyone. It's 5 o'clock, so we will go ahead and get started. We are here to discuss a very important issue for those of us who have been following police accountability and transparency. Um, and before we dive into our discussion and what we're here to talk about today, I'll just do some introductions. And so we're very lucky to have with us Judge Carlton Reeves. Judge Reeves was nominated by President Obama in 2010, believe. He is district court judge in Mississippi and is a proud graduate of Jackson State University and earned his law degree from the University of Virginia School of Law. And prior to becoming a judge, he was engaged in private practice at a firm he founded in 2001. We are also lucky to be joined by one of Judge Reeves's former law clerks, Emanuel Powell. Um, Emanuel clerked for the judge after graduating from Harvard Law School. He is now a fellow with Skadden and a staff attorney at Arch City Defenders. And so we're very lucky to have both of you to discuss this opinion, which came out last year in August, right at the height of a discussion or a national concern that we were all having about police violence and accountability after the murders of George Floyd and Breonna Taylor and far too many others to name. And in the middle of that national discussion, down comes this opinion, which, if everyone on the line has not read it, I encourage you to read it and probably read it more than once because it's quite extraordinary and seemed to express a lot of what many of us were feeling during this time. And so I'd like to start with a question to the judge and to Emanuel, whichever of you wants to take it. But what role did those events and where we found ourselves last year play in your approach to this opinion?
Well, first of all, thank you, Tiffany, for having me here in Bavaria and the appellate project. Certainly uh, uh, appreciate the invitation. Are you getting? Do you hear feedback on your end, or is that okay? That's fine. Uh, I apologize. It played a real role in the ultimate development of this decision. Knowing that the first part of the case was decided uh, months, if not a year before, because summary judgment had been granted to take out the city and all that, and for the ensuing months, uh, we struggled with it because the facts uh, were not facts that I liked. The facts were difficult. And to think that this person, this young man, could be treated in that way and ultimately uh, uh, not have a remedy against the offender. So, as we were thinking about how we might approach that, there were a lot of things going on. The the Ahmaud Arbery. I mean, just so many things. We don't want to name everything because it's a much too frequent occurrence of bad things happening uh, between or among or because of encounters that primarily African American men have with the police. So, with that framework and knowing that, uh, we began to write the opinion. I think, and Emmanuel, correct me if I'm wrong, we decided to basically what we call all hands on deck, probably about January of, of 2020. And of course, it wasn't released until August. So many things happened between uh, January and August that helped shape and frame how we ultimately would write the decision. Had we written that decision in 2019 or 2018, it probably would have been different. But there were so many things happening during the course of the revisions and also So it had a real impact. One of the things that caused me to focus on it a little bit more than usual, I think, is that because of COVID, as I have told other people, my family members decided that we would do uh, Zoom calls to keep up with the nieces and the nephews and just to see how they were doing, how they're doing. And one of the Zoom calls was about their thoughts and feelings on the George Floyd incident. And from those conversations with my nieces and nephews who had had actual encounters with law enforcement, uh, that too played a real role in the tone that we were using, the language, the citations, all of that played a role in it.
And I think that that really did come across in the opinion. And one thing that struck me as I was reading it was that it seemed to center not just what happened and what the incident was, but also the effect that it had on the victim of this encounter. And so you talk, for example, about him having flashbacks and being unable to sleep and really getting into the psychological effect that these sorts of encounters can have going forward. And so I'm wondering, and Emanuel, if you want to take the lead on at least starting the answer to this, but as you were writing this, how were your personal experiences with this sort of encounter coming into play?
Well, thank you. And I want to echo Judge Reeves. So grateful to be able to join this conversation. I would say that part of it comes from the briefings themselves. And so we're able to cite this because the lawyers were able to highlight the negative impact that it had and how it related to all of these incidents that we're talking about. Because one of the things we're able to cite is even though this particular briefing was years back, there's so many cases that had happened at that point in time. For me specifically, I have a loved one who was killed by police while I was in law school. And that really inspired me specifically to think about what my career might look like. But as we're thinking about this specific opinion, noting that it's the death that has a ripple effect. So there's surely the harm that happens to the person whenever one of these incidents occurs, but it impacts our communities. It impacts, we see it impacts the nation. It has spurred a movement that is cross country, cross national boundary. And so the idea that when we talk about a small incident, maybe is how people think of it, a typical stop, how for those of us that these killings have an impact for, how that really can be top of mind every time you see a police officer. And so being able to bring that out in this moment, and again, naming that the plaintiff was able to bring that to the court's attention in the briefing itself.
Yeah, and I'll simply add, Tiffany, each one of these encounters that people have, these are real people. And we talk about the reasonable man standard and all of that. Well, it's the perspective of that reasonable is that reasonable person who's driving that car that night, who stopped and kept there on the side of the highway. It reminds me again of what a conversation I had with my nephew, who lives in Dallas with his family. His he posed the question to me, told me different things about his wife being stopped in their neighborhood on more than one occasion. And he said, I've been stopped too with my family. And he said, it is so denigrating. It is so emasculating. They mistreat you there right before your family, knowing you did not do anything wrong. Now, and he's a good kid. He's good kid, family man, good kid. And he says, what am I to do? And you have the power, huh? What am I to do? And all I could do is tell my nephew, who's done nothing wrong, to subject himself to that, to subjugate himself to that misbehavior and stuff, because the outcome could be that he'll never breathe again, that he'll die right there in front of his family members, killed right there before his children and his wife over something that he had nothing to do with. So I think when we start talking about the people who are in a position and authority to decide these issues, when we start seeing this stuff through the eyes of the person who is being demeaned in this way, I think we'll have a fundamentally different sort of view on how it should play itself out ultimately.
And I think that really all of that came across because the opinion focuses on a wide breadth of types of police encounters and violence. And the footnotes in this opinion do a lot of work and a lot of telling the story. And I thought that they were just fascinating. And I think one of the things that really came across for me is that it's not just the fatal encounters, but it's the sort of constant sort of encounter, as you were just describing, Judge Reeves, where you are stopped on a regular basis. And another form of abuse that's mentioned in the footnotes is, of course, sexual misconduct by police officers. And so we need to keep in mind that there are many types of police brutality, and it's not always the ones that you see that turn fatal, but this is something that the community is living with and dealing with all the time. And so having put all of that and told all of that story in the footnotes about the pervasiveness and the sort of wide array of experiences that people have with police, what were you hoping that readers would take away? And I know you just mentioned an understanding of what this is like, but were there other messages that you were hoping to send to readers as they were reading this opinion?
Yeah, one of the things we always do is you speak to the audience, you speak to whatever audience you're writing to, basically. And judges have to be mindful that uh, sometimes storytelling is best for the wider audience because people don't read all this legalese and things of that nature. So I wanted to take, uh, I wanted the readers, those who would read it, to take away some of the thought is that I hear you. We hear you. Not only that, we believe you. And that's what was so fundamentally different about the George Floyd incident than any other. The whole world saw it with their own eyes. Nobody was able to put a different spin on it, or nobody was able to tell you you did not see the whole story. So so I hear you, I believe you, and I want you to know I really want to do something about it for you. That was the message.
Wow. And Emanuel, what about you? What were you, as you're working for as a law clerk, and you're working on an opinion like this, what were you hoping or wishing that would be conveyed through the opinion?
Definitely everything that Judge just mentioned. I think also um, to speak to the depravity of these types of experiences, and they can seem relatively innocuous so often in our media. He just got stopped, all he had to do was comply, things like that. But to show, especially in the facts section, how there's every moment there's this potential of violence that could happen, and so being able to really speak to that and do it in such a way that an average person who's reading it can understand it. As Judge mentioned, not the legalese. And the other thing I think to name is to talk about the role of the courts. That the courts have been part of this question on how the state will interact with its citizens, and specifically how they will interact with those we know are oppressed. So Black people, low-income people, disabled people, women, all of those individuals are identified if you look into the footnotes. Um, and the courts play a role in making it challenging for them to get recourse, despite congressional movement during the Reconstruction era to say, no, you should have an opportunity to seek accountability, even if the prosecutor won't, you can step up and do that.
And you mentioned the history, which is where I wanted to go next, but I want to remind everyone who's on the line that if you have questions, you can feel free to drop them into the Q&A box, and we will, if they are relevant as we go along, then I will ask them, but we'll certainly get to them towards the end. So please, if you have questions or things that you're wondering about, feel free to drop it into the Q&A. And so I think we can move to qualified immunity itself, and the opinion starts on this topic by walking through the history of qualified immunity and how we came here, and how, Section 1983, which is what allows parties to bring suits against law enforcement, federal and state, federal under the Bivens Doctrine and state under 1983, that this statute was passed as an attempt to deal with violence against Black people during Reconstruction. And it was called the Ku Klux Klan Act, to push back on the terrorism that Black people were experiencing during this time, and to really provide a remedy for racially motivated attacks. And so can you, Judge, discuss that history and how you think it should inform our current thinking about qualified immunity?
Certainly. We have to make sure that the right breadth, if you will, and the true understanding of the 13th, 14th, and 15th Amendments. As I've said in other contexts, the 14th Amendment created a new America. America was reborn through the 14th Amendment. And so the Reconstruction Congress saw what their predecessors had done, saw what their contemporaries had done, saw what their neighbors were doing to these newly made Americans, these new citizens who had been here just as long as they had, had been here 200 years already. They decided that we need to do something for this class of people, because we have done things to them that nobody else had been subjected to. We have harmed them in so many ways. So this violence that was perpetrated against Black folk, the newly freed Black people, the Black people who could now vote, the Black men who could now vote, the Black men who can now hold office, the Black men who can now carve a way ahead for them and their families for generations forward. But the backlash to that was the Ku Klux Klan and all that. But the Congress said, hold on, we need to give them special protections and special rights, and we need to give them the tools with which they can beat back these revived oppressors. And so that's what the Ku Klux Klan Act was all about, I think. But over time, we saw the court turn its back. The court, as Emanuel said, we saw the Congress sort of turn its back. We were still seeing lynchings in the 1920s and 30s and 40s, but ultimately the court itself said, hold on. Certainly all of these state actors are not bad people. They are reasonable people, and we have to protect them. And I think that's what the Supreme Court and the courts have done, sought to protect, and instead of, again, looking at the victim of the abuse, assuming that the perpetrators of the abuse are all good people and they don't mean to do any harm. We will look at a reasonable standard through their eyes, not through the eyes of the victim, but through the eyes of them, because all of them are not bad. And and they really didn't mean what they did. That's what qualified immunity has gone to. And it's morphed from not just what a reasonable person might do. But now we got to figure out the person has to be so bad, the clearly established law, beyond debate. You just got to be, it has to be so outlandish. And not only that, we're going to give you another chance. It can be extraordinarily outlandish so long as nobody has done it before. And so you're protected in that sense. And then there are other protections that the judge has sort of carved out, the immediate appeal type of stuff, what I call what others have called the super summary judgment standard, and all the appeals that you have before you are even able to be questioned by the person who you've harmed. So I hope that answers, some of your question. But yeah, the courts have turned it on its head, and now it's not about protecting those persons or sort of empowering those persons who were once enslaved and beaten and terrorized to sort of defending the oppressor.
And I think the opinion on that point talks about, what happens with civil rights statutes like the Ku Klux Klan Act. You have a period where, it's understood that this is necessary, but then it's almost like the court, and specifically the Supreme Court, gets tired, right? And so you have the Reconstruction Amendments and the Civil Rights Act, and then the court comes in the civil rights cases and says, well, how long do we have to put up with this? How long do Black people get to be a special favorite? And the opinion for me, it stood out about the role of the Supreme Court specifically in civil rights and the rights of oppressed and marginalized communities in the United States. And so, and even with the current court, you see, we had the legislation from the civil rights movement of the 50s and 60s, the Voting Rights Act and so forth, and that has been invalidated by this court. And so the opinion seemed to be directed and talking about the role that the Supreme Court specifically plays. And so what is the message if you were talking to the Supreme Court? Is it that this doctrine needs to be recalibrated? Is it that it should be gotten rid of entirely? But what if you could talk to the Supreme Court, would you say about qualified immunity?
We're just the messenger. We just give them the facts, and we sort of paint the picture of this is where we are now. This is how it has played out. One of the things that we do mention specifically, I think, in the opinion, is that we talk about the super summary judgment standard. We talk about the collateral order doctrine, where they have the right to appeal even before a final judgment. But one of the other things that we talk about is that we trust the Seventh Amendment. We trust the right to a jury. We believe that we embrace our constitutional system prides itself on everyday citizens being able to understand and appreciate and having a decision on how the law is shaped. But what the court has done was taken these findings out of the hands of a jury. We ask jurors to decide all kinds of issues, whether somebody should be held accountable criminally to the extent of their life, whether a company has to pay $1 billion in damages, how do you compensate persons who have been wronged, questions of life and death, questions of fact issues. We trust juries with it in all instances except for this one. Reasonable jurors, I think, can look at the facts that walk you through an encounter with a police officer. And reasonable people could tell whether or not a police officer reasonably feared feared of his life or harm in some way, or if that person, the person who is accused, has acted in some way or rightfully should have done certain things. We trust jurors with that. And I think if we gave the jurors more power in this instance, as we do in everything else, that would help some. And that's part of the message. Emanuel might have something else that I may have discussed uh, with them as we were going through this.
Well, I don't have anything to add from, I think, that perspective, but I will name at this point, I am a practicing attorney and a civil rights attorney and have my own perspective, not from the court, and want to clearly delineate that I think it should be abolished. There is no space and time for qualified immunity. It lacks, I think, and these are some of the citations that there are folks like Professor Schwartz out of UCLA, Professor William Bow, they're talking about the idea that it's both unmoored from its history, just as Judge was mentioning, the purpose of the statute itself, Section 1983. It also lacks a purpose for today. It has qualified immunity, as Judge mentions, creates this super summary judgment opportunity for police to be able to completely stop the case so that there's no discovery. A family can't even ask a question about what happened to their loved one. And the court, this opportunity, civil rights cases are the opportunity for a family to just basically understand how their loved one's life was taken. And qualified immunity says that doesn't happen. Everything stops because of this. And so I would say it definitely needs to be abolished. Also, and one of the things that doesn't get touched deeply in the opinion is that there's two steps to qualified immunity. And that first step of whether or not there is a constitutional violation. There are a lot of existing rules. You can go to Rule 12b-6 and say, dismiss for failure to state a claim. There's a range of procedures that are possible to get rid of cases that are not correct. And so the need of qualified immunity, I don't think is there. And as many have mentioned, it doesn't really make sense given the statute itself.
That's an interesting point, because one thing that I find interesting in this moment about qualified immunity is that there seems to be a cross-ideological push to get rid of qualified immunity. You have originalists who say that it is unmoored from any originalist interpretation of Section 1983. You have, of course, liberals who say that this doctrine needs to be abolished. And so there seems to be, on all sides, an agreement that this is a doctrine that at least we need to look at carefully. And of course, we have been asking the Supreme Court to do that. They have not done it yet, but hopefully, Emanuel, you will get your wish that it is abolished entirely, because I agree with you. So this question is really, I had a question from something that I thought was interesting in the opinion, and then we have a question that has come through in the chat, and I'm going to try to combine them both. But the opinion asks a question, and it says, if Section 1983 was created to make courts guardians of the people's federal rights, what kind of guardians have the courts become? And so I'm interested in your thoughts on that. Where does this doctrine, in that it ties courts' hands and how they deal with police violence, what have the courts become? Like, what powers they really have to guard federal constitutional rights? And the question that came through in the chat, which I think is related, is, did you hope that federal judges would take a particular message from this opinion? And if so, what was that message?
Again, making sure that everybody who reads it understands that there's a victim in this case that ultimately might not have any recompense. We have to, you have to understand, to go back to an earlier question, have to understand what this sort of super summary judgment, sort of collateral order sort of doctrine has created. We have to remember that you file for the law students on this call and for the young lawyers on this call, you file a lawsuit claiming things. That's your complaint. And so long as your complaint states a claim, you are legitimately, in every other sphere, entitled to discovery so that your allegations can be tested by the defendant and so that you can put meat on the bones of your allegations. Qualified immunity says, hold on, disregard all the rules of civil procedure. It's not about getting to the truth anymore. Disregard. They raise qualified immunity. You're not entitled to an interrogatory, a deposition, a request for admission, a request for production of document, a subpoena. You're not entitled to anything. It says that the defendant shall not be subjected to any discovery tools. So, okay. So the judge makes that decision. And if the judge says that the person is not entitled to qualified immunity, that person has a right for an immediate appeal. Now, most people like Emanuel, who Emanuel represents, and his cousin, and well, the family member who was killed, they have a tough time trying to find lawyers to take their civil rights cases. So it takes you a while. It happens that the incident may happen on February the 9th, 2021. You may not find a decent lawyer, a good lawyer, who is willing to take the case for another year. You might have a 2-year statute of limitations. May not be able to take it for another year. He does his investigation, files it 6 months before the statute of limitations ends. But he cannot get into discovery because, okay, the district court has now said, yes, you're entitled to it. There is no qualified immunity. The police officer though says, no, I'm entitled to it. I'm going to get my immediate appeal. So now it's 2022, 2023. And if that 3-judge panel agrees with the victim again, that person, the police officer has a right to ask for en banc consideration or whatever. But it goes all the way up to the U.S. Supreme Court, which could be 5 or 6 years down the road, and that person has had zero discovery. And the Supreme Court may say, you know what? You're right, officer, you're not entitled to qualified immunity. Well, what good has that done that victim? Because 6 years have gone by, his witnesses are gone, everything is gone about his case, so now he has no case to prove. Now it's much more difficult for him to try to prove his case. So I say that. So I wanted judges, I wanted people to understand and to see how this doctrine has done more harm than it has good.
I can say, having read the opinion, that definitely came across very, very powerfully. So it was successful in that way. One thing that I wanted to ask you, Emanuel, about, because I noticed in the opinion that there is a reference to today's abolitionists and the view that was expressed in Reconstruction, and now the view of today's abolitionists is the whole damn system being guilty. And so I know you identify as an abolitionist, and can you tell us what that means and how you think it relates to this opinion?
Definitely. So the whole quote, and I think it's a chant by Southerners on New Ground, which is a movement organization based in the South, is no cops, no jails. The whole damn system is guilty as hell. And so if we look at the current abolitionist movement, and I think for the law students, folks looking at it, New Jim Crow gives you this concept that our current system of incarceration, which is based upon punishment, exiling people from the community and harming them, less so on rehabilitation, that system finds its foundation in the system of Jim Crow, which was a system of oppression for Black people. And then Jim Crow obviously finds its history in slavery. So all of this is all part of the same system of oppressing Black people. And so today's abolitionists, and again, I do identify as an abolitionist, say our system of mass incarceration, our system of incarceration, our system of policing, that this is a system that has no right to be here. It is a system that should not exist. If we want true safety, we know that systems of policing and incarceration do not provide it. And so being able to one of the things I think is so interesting about practicing law is we are, minor historians who are tracking what has happened in the past to give us an idea of what the future should look like. And as litigators, we're trying to use that precedent to make a case for what the future should be for our particular client, but also the law in and of itself. And so the opinion being able to name how these moments where we, those of us who identify as activists, are trying to push for liberation from oppressive states and from systems of oppression, how so often we are met with courts that create barriers. We're met with so much backlash, and how that is, if you look back at the history, it has happened every time. So when we tried to fight against, as Judge mentioned, the Reconstruction era, when you're trying to actually get liberation for people post-slavery, there was an exceptional backlash that happened in both the courts and generally. And today we see abolitionists and the activists who are fighting that. Even if we look, for example, at what happened on January 6th, so much of that conversation and so much of the rhetoric is oriented towards Black Lives Matter and protests and that. So many of them come out of the abolitionist context. So just to name that we're still in that moment. And I think separately, though, one of the interesting things about the role of a court or a lawyer is we have the opportunity to archive what's happening in this moment. And so the opinion provided space to name that there are abolitionists today fighting just how there are abolitionists in that same trajectory fighting back for Jim Crow back during the Reconstruction era.
And on that point, just there's so much in this opinion in terms of the historical record and the legal citations. How did you just logistically go through and put this record together? Given the current demands of what I imagine is a very large caseload for you, Judge.
No, one thing I pride myself on, Tiffany, I've been able to find the absolute best law clerks that the world has to offer each year, and I do. If it's one thing I can pride myself on, is being able to. It seems like it has worked out perfectly each year, putting together what my chambers look like and who are in my chambers, and having a dedicated group of law students, lawyers, young lawyers, who are as passionate as I am, or as passionate as I was as a young lawyer, who did not matter doing what it took to get the work done. Emanuel sort of led the charge on this particular case, but I tell you, it was all hands on deck because Tiffany, you've clerked before. That was not the first draft that ended up coming out in August. No, indeed. There were some things in it that they told me, Judge, you can't say that. You shouldn't say that like that, Judge. So having a dedicated group of young lawyers who understand how important it is for their historical record, who understands how important it is to make sure it captures one's attention. The idea of naming the names, that was important to us. That was it might have been Emanuel's idea, may have been somebody else, but that was very important to us. Once we thought about that, then we started thinking about whose names, what names, and we named the names, and it was important for me. Footnotes 9, 10, and 11 mention some young persons who were killed at Jackson State. Well, two of them were killed at Jackson State, one of them killed in the city of Jackson. Not that it just happened at Jackson State necessarily, but it happened 50 years ago. So this phenomenon of didn't start with Abner Diallo or didn't start with George Floyd. we did not mention Emmett Till, but you mentioned Tamir Rice. It happens to any young person, XY chromosome, XX chromosome with Sandra Bland. It happens to us all in so many different contexts. Philando Castile. So it was all hands on deck. It was coming up with creative ideas, and it was pushing back against the judge, saying, "Judge, you really can't say that," because there were heated discussions about what language is to be used, and well, if we say things like this, might it take the attention away from what we want? Because the focus will be all about what you said right there. That's some real. I mean, it was all hands on deck, and it was a full commitment by everyone.
And only thing I would add was just, unfortunately, all the lower courts, there's so many cases, there's not enough judges to take. But I think a great thing about clerking for Judge Reeves was his ability to give us priorities, his ability to help us think through where this case or that case is going. So I think a lot of it also was just having Judge Reeves, who's able, given his years of experience, to tell us like how to get our day-to-day work done while working on this really important project. Because I think that was important for me with thinking about how to manage a lot of the work.
And we have a lot of questions about qualified immunity and questions directed at the opinion. But Judge, since you mentioned law clerks, I want to just go there next, and then perhaps we can come back to qualified immunity, because I know this is something that's important to you and something that's important to the appellate project. But the role of having diverse law clerks who can bring this sort of experience to the table. And so one of the questions that's come in is, what do you look for in law clerks, and what would you say to young diverse lawyers who are interested in serving as law clerks?
I think if you've worked really hard in law school and you appreciate what you did in law school and undergraduate, I think anybody could be a law clerk. That's number one. Despite what your law school might tell you, or despite the fact that you're first generation, you don't know anything about it, you don't know any lawyers. Many people can be a good law clerk, and there are many great judges out there on the state level and on the federal level, Article 3, Article 1, state court of appeals, state district courts, trial courts. What I look for is just someone who thrives to learn, and that sort of reads through your transcript, your resume, and things of that nature. It helps if you're on law review, I guess, but that is not a factor for me. I know for some judges, they say, I only get people on law review and I only get the top 10% of the class. Not for Carlton Reeves. Now, it might help if you have some of that, but no, I look at what type of did you have any sort of practical clinical type stuff? Because I like to see people who sort of like me want to see if how they dealt with everyday people, persons who bring something interesting about their life. I like first generation people, because guess what? I'm a first generation person. I like them. I like people who are different, who are going to add some sort of, I wholeheartedly believe in diversity. I've had all kinds of law clerks because of the different perspective. We have different kinds of cases here. I've had the opportunity to just rule on a number of different kinds of cases, including abortion, for example. And I get the most joy out of seeing what other people say when they read the decisions, because I go to Twitter every now and then, and somebody said, ooh, a woman, it almost sounds like a woman, wrote that. Yes, a woman had a hand in writing it. Yes, because, one of the clerks was a female that year. And it's so important because the drafts that I gave to her that we were pushing back on each other, guess what the female said? No, Judge, you don't want to say that. She said, because this is how it sounds to us. And that difference of perspective is so important. So I look at your broad range of experience. I've had law clerks who have done other type of stuff before going to law school, who have been practicing lawyers. But I've also had people who were just like me, 4 years of undergrad, 3 years of law school, straight to clerkship. The most important thing about a clerkship, I believe, with me is that the clerks are, I've gone out of my way, if you will, gone through all the resumes, and I've selected 2 people out of about 85 or 100. These are the people who I invite into my clerkship family. So I'm hoping there's a lifelong connection, like the judge and I have for me, for mentorship, for friendship, for love. I feel that way about my law clerks. So I look at those type of people who I want to be connected to for the rest of my life. And I want them to want to connect with me for the rest of their lives.
Yeah, I think that's so important. I remember working with Justice Sotomayor, and she refers to us actually as all sweetie. We're all sweetie, no matter what our name is. But more importantly, she says we are a family, and we disagree. These cases are hard, but like at the end of the day, we are family, and she cares about my children and asks about them all the time. And I think that part of the relationship, when I was thinking about clerkships, it was not just what it would do for my career, but the opportunity to have these mentors who can pour into my life and that I can learn from and have a lifelong relationship with. And I just think, that is sort of an understated benefit of clerking, is the relationship that you establish. And so, Emanuel, I know that we've talked about what it's like being a minority law student, and like sometimes your law school doesn't pick you out and push you to apply because we don't typically get that type of attention. But what would you say to the students on the line who are interested in clerking? And tell us your clerkship story and how you came to be a law clerk.
Definitely. If I was to say, definitely clerk, if you're interested. It was and has been, I'm early in my career, but I can tell that this was just one of the most impactful, powerful experiences I've had. And I worked, Judge Reeves is somewhat talking about me as one of the examples. I worked before law school. I was in law school. I was very focused on clinical work. So I was doing eviction defense cases, helping and organizing spaces in Boston. Um, and never thought I could be a clerk. Like, it just wasn't necessarily. And like you said, no one came to me and was like, Emanuel, you're doing really well in your clinic. You should be no, that never happened. And still, and I went to Harvard, and I identify that as definitely a privilege. And there's definitely people who I know were on that track, and it just didn't seem like something for me. But one of my friends that I made while I was looking at law school, she was at Stanford. We became friends because we were talking about Judge Reeves. I'm from Mississippi and I'm queer. And when Judge Reeves' opinion about marriage equality came out, I was like, I cannot believe this is happening from a judge in Mississippi. Who is this guy? And we're talking, and years later, she's clerking for Judge Reeves, and out of nowhere, she sends me a message and says, Emanuel, you have to put in an application. I know you love Judge Reeves. We were talking about him. This is why we're friends. Just put in the application. I just figured it out really quickly, somewhat by myself, talking with my professors who I was close to. And, Judge Reed gave me the opportunity. And I'll just want to name that in my acceptance call, he said almost verbatim what you said, Justice Sotomayor told you. This is a family. We're going to argue. We're not going to agree on everything. And at that point, he didn't know I was an abolitionist, so he didn't know how much we were going to disagree on things. But it has been this experience of having this family and for Judge Reeves, really diverse lawyers who are doing all types of work, who I've randomly, met, had a conversation with. And Judge Reeves is the person that I definitely am thinking, like, where's my next, what type of lawyer am I going to be? How am I going to do that? I know I have the example of Judge Reeves, which I didn't have in my family. Don't come from a family of lawyers or things like that. So um, I would say any advice would be definitely, if it's something you want to do. I've learned a lot. I bring it to my work litigating cases now. And it might be more challenging because there are, jurists like Judge mentions who may not have an open mind about who can be a great clerk, but sit down and do the research, think through it, and really lean on your friends, because it can be a really challenging process. But for me, it's been a really valuable one.
And Tiffany, if I can say this one thing, because I know there are probably students on this call from everywhere, and the generation that I deal with now, in the pool of applicants, are the generation like Emanuel, people who, you young people, you all will pick up and go somewhere, do your international travel, will take time off, and who will go to Thailand and live on the ground for 60 days or a year, do adventurous things. Not like me. I mean, I would not have been as adventurous as you all are. But I want to tell you that because you all are that adventurous, please think about clerkships and judges off the beaten path, because there is litigation and great things going on anywhere. And when I say off the beaten path, I'm talking about your state courts too, because there are excellent state court jurists. And state courts will be doing some dynamic things if we take to heart what the Supreme Court and others tell us about federalism. We know that there's a lot of things that the federal courts will not be a part of that the state courts will be. So think about judges on the state court system. Think about, if you want to be if you want to be a ADA, assistant district attorney, or public defender, what better place to clerk than a state court trial judge, where you will see the stuff at the first instance right there, instead of maybe the state Supreme Court. Now, I do not knock the state Supreme Court, because that's the avenue that got me to where I'm here. So I just tell you, just think about other places. Everybody doesn't have to try to get to a clerkship in DC, New York, LA, Houston. Think about El Paso. Think about San Antonio. Think about Springfield, Illinois, as opposed to Chicago, Illinois. Think about Albany, Georgia, as opposed to Atlanta, Georgia. They're out there. There's some excellent judges out there, and it's about to be more excellent judges out there. It's going to be a crop of judges who are going to be, if everything plays out like people are saying and predicting, it's going to be a new batch of judges who are going to bring all kinds of experiences into the bench, including demographic experiences. So I would say, do not overlook any jurisdiction, whether it's Iowa, Idaho, or Montana, or any state in between Seattle and Miami.
I agree with that. And I wish, I remember when I was putting together a list, and I at the time, I think our son was 3 or 4, and just being disappointed that I felt like I was trapped in, I could only apply in one geographic area, when I knew that there's a world of judges all around the country, that I would have loved to have clerked for. So I would also encourage all of you who are on the line to just cast a wide net and think hard about not always aiming for DC, New York, and the more popular or larger cities. So Judge Reeves, we have a question for you, and it's about clerking. So thinking about your clerks that have had an especially successful year, what are some of the traits that they have in
common? Many of the ones that I've had have done some sort of public interest work, believe it or not. I've attracted a lot of people, because that's I've attracted a lot of students who've been involved in public interest stuff, either through their law school at clinicals or even having practice. Some of them have done internships with EJI. Others have worked with or either done an internship with the SPLC. It just happened that way. Others, it's that drive to do public interest stuff. You know, and again, I'm looking at diversity as well. I'm looking at women. I'm looking at males, female, Black, white, uh, 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 Asian, Indian, you know, Eastern Asian, Indian, or whatever. I'm looking at all of those things and trying to put together the package because number one, I do believe in diversity. I believe in diversity of experience. I believe in demographic diversity. So that's one of the things. But primarily, most of my law clerks have done stuff from the public interest sort of social justice sort of side. Because frankly, the person who would, I would tell you, Tiffany, the person who would probably have the toughest time getting into the chambers would be a person who is a member of the Federalist Society. Because, and I say that in the sense that there's so many more opportunities out there. I'm looking for the person who won't necessarily have that opportunity that so many others have. I'm looking for the first generation person because that person, that the doors are not generally open as wide to them. I'm looking for the person who's interested in social, who's done, who's involved in not necessarily social justice, but public interest stuff. So many of our people, so many of our law students think about law being the gateway to get to the big corporate firm. There will be opportunities for you out there because there are so many other judges out there who can identify with you, who will gladly open the doors. White males will likely have a more difficult shot. I've had white males, but they have a much more difficult shot. My permanent clerk is a white male. So a white male will probably have a tougher time as well, because I know that there are judges out there who have only hired or substantially hired white males. So I believe that there'll be more doors, more opportunities open for you. I think if we did a global thing among Article 3 judges, I believe you could probably come up with a list of judges who have never had anything other than white male clerks. You can come up with a list of judges who have had nothing but white clerks.
Absolutely.
All right. So I think, well, I think I have to be the gateway for those persons who were just like me. Somebody from a place called Yazoo City, Mississippi, did not have any lawyers in the family, who was willing to work hard. I would tell people every day when I was clerking for Justice Anderson, I may not be the smartest law clerk that he had or the smartest law clerk among all the clerks there that year, but no one was going to outwork me. And so, I felt like I worked till I got to what I needed to do, no matter how long it took. And I guess to some degree, I sort of expect that for those who were. I'm not saying that I work you like a dog, Emanuel, but I just I want to be that gateway or that entrance way for persons who have experienced life as I have, or similar to what I have.
And you did not work me like a dog.
So we have about 15 minutes or so left, and we did get a lot of questions about qualified immunity. So I want to go back to that. This question says, one common justification for qualified immunity is that police need some immunity for making split-second decisions. What arguments, if any, do you have in response to that justification?
Well, I think jurors can make that call. Jurors can determine whether or not there was sufficiently. I mentioned to Tamir Rice. I don't know if ultimately that case was filed. I don't know. I do know. I assume that Cleveland, Ohio, was going to would argue that they're entitled to some sort of immunity. It was not a practice policy. The city would get out, and the officer would say, "Well, qualified immunity." So, no. What split section decision? If that case had been tested, what jury would believe that that officer thought he was in harm's way, that he would jump out of his car and within 2 seconds, I think it was 1.4 seconds or 2 seconds, shoot that child? No jury would find that. But we embrace this notion of qualified immunity, again, seeing things absolutely, not only seeing things through the eyes of the officer, but accepting that what that officer said is actually the barrier or the truth to this. So this whole notion of split second decision, no. Laquan McDonald, there was nothing about split second decision. At what point in time does the decision to stop come in? For Eric Garner, at what point in time do the other officers who see this man saying, "I can't breathe," at what point in time will the officer say, "Hey man, get off of him. Man, you might be committing a crime"? The George Floyd case. At what point in time did it not become a split second decision anymore with the other officers around? So I hear you when you say split second decision. I just think that sometimes, again, we allow jurors to decide everything. Why not this? Emanuel might have something to add on that point. I don't know.
Only thing I would also add is this: to the extent we, I think it's Justice Kagan, we're all textualists now. There's none of that in the text of Section 1983. And again, for those of us who agree, like maybe the courts are not supposed to be policymakers, we think that's a role of the court. All of this comes into the court saying we need to protect the cops. When we know that the statute in its original form was about protecting the people. And so it doesn't make a lot of sense, I would think, generally, that the court is making those types of policy decisions about this statute, which is very clear that you're protecting people from unconstitutional action. As Judge mentioned, we have a jury to figure that out. That's who's supposed to make those decisions of who's reasonable, not the one person in a robe effectively doing that before someone gets a chance to get to a jury.
Our next question is, any thoughts on the Supreme Court's recent per curiam decision in Taylor versus Riojas? And this is the case that you talked about in the footnotes of the opinion. And do you think that this signals a shift in the court, or is it just an aberration given how horrific those facts are in that case?
I guess it opens the door to maybe a shift, not necessarily a shift, but a reminder to the courts of appeals that, you all, I know this is from the Supreme Court. I know we said clearly established. I know we said beyond debate and all that. But we did not say beyond debate squared or beyond debate cubed. We didn't do that. You all have sort of expounded this to places that are just crazy. And I do note in the Taylor case, those are the most egregious and horrendous facts. What human being could come up with any justification to say what those inmates were subjected, what that inmate was subjected to, was okay or was objectively was objectively reasonable about the officer's conduct in dealing with that person. So the Supreme Court said, "Oh, no. Remember, we decided Hope versus Peltz, I think it is, when Justice Stevens was on the bench, because I think it was his case. Said, he said, it's only about fair notice. So maybe they're just reminding the courts of appeals. I know we haven't said fair notice in a while, and we've sort of said all of these other things, including that. I think it's the Westby case out of the DC circuit. I think it is. It might have sounded to you all like we said that there's no hope for no hope to get rid of qualified immunity, but we really didn't say all of that. That was y'all judges on these courts of appeals who have just twisted and expanded our language far, far beyond this fair notice thing that we have said in Hope versus Peltz, and then I think even another case that they did. And so maybe they might be just reminding us that it may be a fair notice standard and not all of this other stuff. It may be. Emanuel doesn't think so, but it may be.
No, Judge, I'm hoping it's true, but I have a feeling it's more of the same, where the court is. There were so many cases, I think 14 plus years prior to since Hope. And I know as a litigator, I'm definitely doing exactly that. I'm going to cite Taylor every day for the hope that the facts that we have are so egregious. But
yeah, the Taylor facts, please go back. And I would suggest to the people to go back, start with the footnote, but go back and read the district court opinions and read the magistrate judge's opinion. And of course, read the Fifth Circuit opinion. Read all of those opinions, and you tell me you can walk away in a society in the United States and believe that there is anybody in law enforcement who could believe, or any human being who can believe that the way this person is treated should be constitutional, period. I don't care if it happened to anybody before or after or whatever. If you can walk away from there thinking that it's okay, something is wrong with our society. So those facts in that case were so egregious.
Horrific. For the folks on the line who might not be aware, just briefly, it was a gentleman who was kept in two different cells. One was covered floor to ceiling in feces, and it was packed inside of the faucet. And it was. I also encourage you to read those opinions, and particularly how the Fifth Circuit reasoned that qualified immunity applied.
What? Can I just add one point? Mm-hmm. And for 6 days. That's the magical part. 6 days.
And that was why qualified immunity by the Fifth Circuit was appropriate, because we have cases saying that, this many days is not okay, but this was, as they put it, only 6 days. So he only had to live like this for 6 days. It was difficult to read the Fifth Circuit opinion in that one. What is your advice to civil rights attorneys who are litigating in this space, the qualified immunity arena?
Continue to, I'm using this word again, continue to have some hope. Fight hard for your client. I did 1983 defense when I was in practice, but I also did 1983 from the plaintiff side too. You have to fight for your clients. That's you are the guardian over them. They have that one case, and they've brought that case to you because you're their only hope. And so you have to understand that in all likelihood now, the police officers in the city have been sued before, or the defendant in your employment case been sued before. But the person who has been a victim of something, or who they believe have been victimized in some way, this is their only case. And you have to represent them in such a way, and that's how we sort of judge here and act as a judge here. We have to make sure that these people are satisfied with this system. so satisfied that if it were to happen to them again, they would come back to court to resolve the differences. Same for you all who are struggling with your clients. You want your clients to feel like, if, even though I lost this time, if I'm ever in a situation again, I'm gonna go back to my lawyer because he or she did everything that I thought that they could do for me. It just didn't work out the way it should. But you just have to keep fighting. You have to keep, you can, and I use this word again, hope. You can, you can never lose hope. I mean, and I sort of think about the Thurgood Marshalls of the world in the 1920s and 30s, and you know, when they were fighting Swain cases and things like that, and finally he sits on the court to decide Batson and dissent to Batson. I mean, you know, saying that's not enough, but you know, taking each small victory and strategizing and thinking about how we're going to push back against this doctrine or that doctrine, separate but equal. We're going to do it. We're going to do it a chip at a time, or, you know, just think about every one of your cases and think about how you ultimately change this system as abolitionists would, you know, blow it up.
Well, I appreciate Judge naming abolitionists in that I'm new to the game, but one of the place I'm at, Arch City Defenders, we're committed to working with organizers, with people. So it's not just lawyers. The movement, change happens. Yes, we're part of it, but there's a lot of other people and a lot of other players. So the opportunity to reach out to those organizers, put those who are most impacted at the center, that's also something that's on us to do and what we can do so that, yeah, 60 years, it might be 60 years from now that we overturn Plessy, but that's worth it maybe.
And it might not happen in your lifetime, right? But like it's worth, yeah, I remember struggling with this after the election in 2016, and I was clerking, and I thought the election was so devastating. And I started thinking, like, why would I dedicate my career to civil rights when this is the Supreme Court that I'm going to face? And I happened to go to a Ta-Nehisi Coates event, and he just got me together. He didn't even know he was talking to me, but he said, who are you to expect that you get to see victory in your lifetime when there are ancestors that were born as slaves and still did the work and worked as abolitionists and never got to see the fruits of their labor? So who are you? Who are we to say we have to see all of the success in our lifetime in order to think that the work is worth doing? So we have to keep at it, even if it doesn't always appear that we'll get to see the fruits of our labor. So we have 2 minutes, and I saved a favorite question to the end. So there's a question that came in, and then I'm going to add on to it. So the question was about the Star Wars references in the opinion, and how did that happen? And did you worry that it would take away from the seriousness of the opinion? And then I would like to add to that the Wizard of Oz footnote, which was a favorite of mine. Like, who is the movie buff and how did that happen? And did you worry that it would take away from the seriousness of the issue?
I could tell you about the Wizard of Oz one. When I was conceiving and conceptualizing the stop, I do go to movies, and my daughter likes movies, and that's how we used to do. The family used to go to movies a lot. 150 minutes is a long time. I think it was an hour and 50 minutes, whatever it was. That's a long time to be on the side of the road. And I knew that everybody had been, I assume most people go to movies like I did. So the original thought was, for me, I said, well, you know, Black Panther was 2 hours and something long, you know, that, and the Avengers, it was much longer. Something was long. I was looking at these highest grossing movies, and those were what I was focusing on. And I said, clerks, I'm trying to think of movies, and I'm also trying to think of, you know, I'm not the mathematician in my chambers. So I said, come on, man, y'all help me think. how many miles would this person have traveled in this amount of time if they were going 70 miles an hour? It would put the person all the way in Alabama, closer to home and all that stuff. So, so I was coming up with movies and things like that. And they came up with The Wizard of Oz, which was perfect, because everybody has seen The Wizard of Oz and got a favorite scene in The Wizard of Oz. So the law clerks came up. I don't know which one came up. Now, I'll give you this hint about the Star Wars reference, and I'll let Emanuel tell you how they came up with that. I have not seen a Star Wars movie, period. I have never watched one in full. Never.
Me either.
Oh,
So
no.
one of my law clerks, well, all of them had seen Star Wars and know about Star Wars. One of them is a Harry Potter fan and all of that. And, you know, so we talk about movies all the time. But they'll tell you how they came, because they did come back. They came up with the Star Wars thing. And they said, well, what you think about it, Judge? I said, well, I mean, y'all know more about it than I do. And so Emanuel could tell y'all how they came up with Star Wars.
Yeah, I think part of it, just to both sides of the question, one is it took us, this is a long time. So Judge named January to August. And so I'll name something that is like, how do you create something interesting that is going to be more accessible was a question. Most judicial opinions aren't that accessible. So how do we make something that's accessible? And so that's where being able to bring in movies or like TikTok references, things like that, that we know people are talking about these issues, not just in courtrooms. And then also telling a story. Star Wars was an amazing story where you did have someone who you thought was going to be good, turns out they're terrible in many contexts, like the Supreme Court a lot of times when it comes to civil rights. And so being able to say, you know, here's a popular reference that other people can maybe appreciate.
Well, we have exceeded by 2 minutes our 6:15 stop time. So I just want to say thank you so much to Judge Reeves and to Emanuel for talking with us today. This has been a great discussion. I will close by encouraging all the students and practitioners on the line to check out the Appellate Project in our social media. Our goal is to increase diversity in appellate practice, which is one of the whitest areas of the profession. And we are working to change that. If you are a student who is interested in appellate practice, I encourage you to reach out and get involved with our mentoring programs. And if you are a practitioner or at a law firm, I would encourage you to express interest in becoming a mentor or give and donate to our work and our causes. So thank you to our guests. This has been a wonderful conversation, and I think we will end it here.
Thank you so much, Tiffany. Thank you,
Thank
Emmanuel.
you.
And thank you, Javaria.
Bye, everybody.